I think he's on a pretty substantial cash bond on that case, Your Honor.
Okay, so well then I'm going to adjourn him. I think I have to adjourn him every 90 days. Is it every 90 days or 180 days?
I think it's 90, Your Honor.
I think so too. So I'm going to adjourn him for 90 days. And since he's on, since he has the felony matter, I am going to give him a bond. Okay, so I want him to, I don't know what's going to happen with the felony, but well, I do know he's incompetent to stand trial right now. I suppose they're going to keep him in custody, deemed incompetent, and get him treatment while he's in custody. But as it relates to the misdemeanor cases, I'm going to set his bond at 110% plus a GPS tether, and then he can be tethered to a treatment facility if we get to that point. If the felony matter goes away before my matter, but at this point, unless the people dismiss his felony, he's not competent to stand trial. All right, and then what's his date in Judge King?
I'll go back. I think it was May 6th. Your Honor.
All right. Well, so I think we also have to get him reevaluated within after the 90 days. He needs to be reevaluated to see if competency has been restored. So I'm gonna adjourn him to May.
Yeah, it's May 6th, 2024 at 8:35 a.m., Your Honor, before Judge King.
Okay, well, I'm gonna adjourn him to May 17th. And I'll order, so the court order is that he is not competent to stand trial and that he should be reevaluated in 90 days by the forensic center, and he will come to me May this whatever date I just said. I'm sorry, May 17th. Anything further?
From the people, Judge. Thank you.
Nothing on behalf of Mr. Barnett. Thank you, Your Honor.
All right, Mr. Barnett, I'm going to see you in 3 months, okay?
3 months. Your Honor, I got a question.
Okay, what's your question?
My brother told me when I get out, he was gonna set up a job for me to work, Miss Judge Bryant. And I was wondering, my bond is $10,000. I was wondering if you want to lower the bond from 10%, I could have got out for $1,000 for on bond because I really been in a lot of pain in the agony in the cell of my feet, numbness in my foot, and spine condition.
Mr. Barnett, let me interrupt you. So I'll mark your file medical, make sure that they get you some medical attention. But your bond for me is not $10,000. That's your bond. That might be your bond for Judge King. I give your bond for me is only $100, 10%. So somebody would only have to pay $10 to get you out on my bond.
Oh, okay, I see.
Yeah, but you have to ask Judge King about the other bond.
Okay.
Okay, so maybe you can try to contact your lawyer on the other case and see if they can ask Judge King to lower your bond on the other case.
Okay.
All right. All right. I'll see you in May, Mr. Barnett.
Okay.
All right, have a good day. Stay safe.
Yes, ma'am.
All right, bye-bye. All right. Ms. Stevenson, did you need to get ready on Sherelle? Oh, Sherelle and Edward?
Yes, I do, please, Your Honor.
All
Well,
right.
if the court wants to call Sherelle, I'm ready on that one. Or if you want me to do both of them at the same time, I could do that as well.
No, we can be ready. We could get ready on Sherelle.
Okay.
All right. Counsel, it looked like you driving, so you could turn off your camera and keep driving and then come back on when you finish driving. All right, I'm ready on Sherelle. All right, this is case number 214408101, the people of the state of Michigan versus Antonio. The middle name might be cut off. It might be Marquis Sherelle. Defendant is charged with 1 count of larceny, 2 counts of assault or assault and battery, 1 count of disorderly disturbance. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Antonio Sherelle. Good morning, Mr. Sherelle, sir. Please tell the judge your full name.
My full government name is Antonio Burns-Sherelle. I had 2 last names. I'm not sure if they're not including the first one.
Mr. Flanagan, what's the middle name that we have in the system, please?
Middle name Marquis.
Yeah, my legal name is Antonio Marquis Burns-Sherelle.
All right.
That is the AKAs on the complaint.
Okay, thank you. Today's the day set for pretrial conference. How are we proceeding?
On behalf of Mr. Burns Sherelle, Your Honor, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter?
Your Honor, I barely heard Ms. Stevenson, but if the court, it's the first pretrial conference, Your Honor, and I don't see the complainant witnesses in the waiting room. However, the people are asking for an adjourned pretrial conference to give the complaining witnesses 1 more opportunity to appear before the court.
The court is going to deny defense counsel's motion for dismissal, grant the people's request for an adjournment, giving them an opportunity to locate and notify the complaining witnesses of their obligation to appear before the court. Mr. Flanagan, how many on April 1st?
$20.
And does that include the magistrates already, or is that all me?
Oh, yes, Your Honor, that's the magistrates. They put 10 on.
All right, the court is going to set the matter for Monday, April 1st. At 8:36. The complaining witnesses are required to appear. Failure of the complaining witnesses to appear will most likely result in the matters being dismissed unless the people have a valid explanation as to why the complainants could not appear or should not be required to appear. Bond will continue with no contact with the complaining witnesses. Anything further?
No, thank you, Your Honor.
I don't have anything further for Mr. Burns Sherelle. If he could wait for me in the hallway, I'd appreciate that.
We can barely hear you, Ms. Stevenson, but Mr. Burns Sherelle, wait for your lawyer in the hallway. I mean, Ms. Stevenson, it's not that the mic isn't working. You talking low. You know you talking low.
Okay.
You like you whispering. If Mr. Burns
Okay.
should be waiting.
I'm trying not to shout. Oh,
Well, shout. We want you to, because Miss Ritter said she couldn't hear you. Nah. We don't care. Just shout, Miss Stevenson.
permission
All
to
right.
start yelling. All right.
Yes.
Take that.
Okay, you can go ahead and get Edward ready.
Thank you, Your Honor.
You're welcome. Mr. Copeland, if I could hear your voice, I'll let you turn on your camera.
I'm trying to turn on my camera, but
No, you can't. I needed to hear your voice. You know, we're live streaming now. We have people who.
Good morning, Your Honor.
We have people who you know, try to come in under somebody else's name. All right, you should be able to start your camera now. Oh, get Miss Stevenson back. I'm sorry. Mr. Flanagan?
Yes, Your Honor.
Not Mr. Flanagan. Officer Kraft. Officer Krafts, get Miss Stevenson back for a minute.
Okay.
I don't know, Mr. Copeland, you kind of look relaxed.
Kind of. I just got to work.
Oh, look.
Found out I needed to be here.
Okay. I'm like, he look relaxed. He looked like he'd been on vacation or something. Miss Stevenson, I was just bringing you back to acknowledge Mr. Copeland. Which cases are which cases are his?
Meyer, Blackburn under 830.
You said wait a minute. Oh, Blackburn, okay. That's the only one? Because you have a lot of retail fraud cases on the docket.
Yes, sir.
That's the only one for Mr. Copeland?
Yes, sir.
All right, Miss Stevenson, you acknowledge Mr. Copeland's presence for Blackburn?
Yes, I do, Your Honor. Thank you.
All right. Well, Mr. Blackburn is here. Do we want to go ahead and do it right quick while Mr. Copeland is here?
Actually, I think we probably want to.
It has a plus sign next to it, Miss Stevenson.
Okay. Yes.
Mr. Blackburn. Mr. Blackburn, start your camera, please. No, he's not ready, Mr. Copeland, so.
Yeah, I'm ready. I'm right here.
Okay, well, okay. All right. This is case number 234403801, the people of the state of Michigan versus Andre Maurice Blackburn. The defendant is charged with the defendant is charged with 1 count of retail fraud. I'm not sure which degree, and today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, and it's retail fraud in the 2nd degree, Your Honor.
Thank you.
Janice Stevenson appearing on behalf of Mr. Andre Blackburn. Mr. Blackburn, sir, please unmute and say your full name.
Andre Maurice Blackburn.
And Ms. Ritter, you didn't want to acknowledge the complaining witness on the record?
Sorry, Your Honor. I have a representative on behalf of Meyer, Mr. Copeland, present this morning. Mr. Copeland, can you put your appearance on the record, please?
Pardon me?
Can you put your appearance on the record?
Yes, I can barely hear you. I don't know what's going on with this. So I'm trying to get closer. So
say your name for me, Mr. Copeland.
Pardon me?
He can't hear us. I said, say your name for me.
Robert Copeland.
And you're a representative from Meyer, correct?
Yes, ma'am.
All right. Today is the date set for pretrial conference. The complaining witness is present. Ms. Stevenson.
On behalf of Mr. Blackburn, Your Honor, we continue the plea of not guilty. Ask that the matter be set for final pretrial conference. We would request discovery.
All right, the court is going to continue a not guilty plea on behalf of Mr. Blackburn and set the matter for final pretrial conference, April 22nd at 9:00 a.m. Discovery should be submitted to the defense by March the 22nd. Bond will continue with no contact with any Meyer store, Mr. Blackburn. The complaining witness is Meyer Corporation. You can't have contact with any Meyer while the case is pending. Anything further?
Oh, thank you, Your Honor. Thank you.
I don't have anything further for the record. Could Mr. Blackburn please be returned to breakout, Your Honor?
All right. Mr. Copeland, thank you so much. Have a great day. Stay safe.
Thank you. You have a good day.
Thank you. Mr. Blackburn, I'm going to return you to the breakout room. I'm going to move you to number 10. The lawyer wants to speak with you again. All right, Ms. Stevenson, you can go ahead.
Thank you, Your Honor.
All right. Mr. Blackburn, return to the breakout room. I think, okay. He's frozen. Oh, Ms. Ritter, I guess I could let in your witnesses. Ms. Foster, I'm going to send you to a breakout room. The prosecutor will come in shortly to speak with you. Ms. Ritter, you could go ahead.
Okay.
All right, good morning, Mr. James.
Hold on a second, Judge. I can't. There we go. Good morning.
All right, you finished, you made it to your location?
Yes, I'm at Frank Murphy right across the street from you.
All right. Your client is here. Oh, the prosecutor just went in to speak with one of her witnesses.
Yes, I would like to speak to the prosecutor in the breakout room as well, if at all possible.
It might not be possible.
That's fair.
Don't y'all know how much I hate that? Y'all don't spread the word. Judge Bryant hate when we come to court and we say we need to speak to her one and only prosecutor.
I'm gonna spread the word for you, Judge.
Spread it. I'm gonna try to get a billboard, but I think they might get me. I will send you to a breakout room, and when she comes out, I'll ask her to pop in to speak with you.
It'll be brief, Your Honor.
All right.
Thank you.
You're welcome. Miss Ritter, your witness is on the phone with the courtroom. You need to call him, and so he could get his audio working. But Mr. James is in breakout room number 14. He wants to talk to you.
Okay, Judge.
Okay. Mr. Flanagan, you have the phone, or Miss Ritter, you have your witness's phone number?
I do, Your Honor.
Okay, because bless his heart. I can send him to the breakout room. Let's see if he'll go, but I mean, let's see if he'll go. Because bless the name of Jesus. Oh, I don't think I was supposed to say that on there. All right, I'm gonna send Miss Foster to back to the waiting room.
Okay. Okay, he went just, so I'll talk to Mr. Jeans and then go into their breakout with them.
All right. All right, you want to do Mr. Jean's case first, or you gonna go in with your witness?
He left and he's in a waiting room, so we can do his case first.
Oh, why? Okay. Okay. All right, I'm ready on Allen. This is case number 234432601. The people of the state of Michigan. Wait a minute, that might not be right. That's not the right case number, I'm sorry. Case number 234427001. The people of the state of Michigan versus Tarina Albertina Allen. Defendant is charged with 1 count of stalking. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, and the complaining witness is still in the waiting room, Judge Brown.
Oh, yes, I'm sorry.
And I have the complaining witness present via Zoom this morning. Ms. Foster, unmute yourself and state your name for the court, please.
Janice Foster.
Good morning, Your Honor. Chester Jeanette, T83295, representing Ms. Tarina Allen, who's present and consents to this hearing via Zoom. Ms. Allen, will you please state your name for the record?
Good morning. My name is Tarina Allen.
And what's your middle name, please?
Tarina Albertina Allen.
Thank you so much. Today is the date set for final pretrial conference. How are we proceeding?
Yes, Your Honor. I had a chance to speak with the assistant prosecutor, and we'd like to set this matter for trial, in-person trial date.
Court is going to continue a not guilty plea on behalf of Ms. Allen. Set the matter for trial. My next trial date is counsel. Let me ask you a question.
Yes, Your Honor.
With respect to the trial date, I could give you a date where you would not be the first in priority, or I could give you a date where you would be the first in priority, and it would be a little later. So the date where your client would be the first in priority would be Monday, October 7th. Otherwise, I could give you an earlier date and you could see if the other case is settled. What do you prefer?
I prefer first.
Court will set the matter for Monday, October the 7th.
And that's a jury trial, correct, Judge?
Yes, sir.
Thank you.
Oops, I'm sorry. All right. Court sets the matter for Monday, October 7th, with a final pretrial conference. Monday, September 9th. And I'm sorry, the jury trial is at 10:30. Final pretrial, September 9th, is at 9:10. If there are any pretrial motions in limine, anything of that sort, they should be filed in enough time so that they can be heard on September the 9th. That means you got to give the opposing side 21 days to respond, and then yourself 3 days to reply. Ms. Foster, you are not required to appear on September 9th, but if you want to, you may. But the jury trial in person, October 7th, of course, at 10:30, you're required to appear. Anything further?
Judge, at this time, any people address bond?
You may.
Your Honor, so I did have a chance to speak with the complainant witness, Ms. Foster. She did indicate to the people that she's the paternal grandmother to one of Ms. Allen's children. And Ms. Allen is continuously harassing Ms. Foster, reaching out to individuals that Ms. Foster knows, speaking about Ms. Foster, and continuously trying to harass and antagonize her. At this time, Your Honor, I am giving defense counsel in the court notice of the allegations I received from Ms. Foster. If the people do get further evidence, we don't have a problem with filing an emergency bond motion and even upgrading the charges to aggravated stalking, which is a felony.
All right. So, of course, counsel, you could talk to your client about that. I'm not going to have a bond hearing right now, but what I'm going to say is that I said what I said when I said no contact. I meant what I said, and I meant it when I said it, and I mean it today. So, I don't know if the allegations are true, Miss Allen. I don't know, because I haven't had any, proof of them, Miss Foster's word. But what I'm going to say to you is, you are to have absolutely no contact of any kind with Miss Janice Foster. That is directly or indirectly. That is through direct contact or through sending a message through somebody else, or posting a post on social media, or putting a message in a bottle, or leaving a message on a car, or anything of the sort. So, counsel, you could talk to your client about it, but Ms. Ritter, if she wants to file a motion for a bond hearing, we'll address it at that time. Anything further?
No, thank you, Your Honor. Thank you.
No, Your Honor, just for the record, my client is fully aware of all her bond conditions, and I will speak with her again about these allegations from the prosecution and move forward amicably if there's an emergency bond issue.
All right, then we're all set. Everyone have a great day. Stay safe.
Thank you, Your Honor.
Welcome. Okay, now Mr. Boffman and Mr. Rubio, I know that you all know that unless you turn on your camera, you really not here. Okay, who is this that we, oh, Miss Rubio, who is this in the jail? I'm sorry. I just brought the jail in. Who is this in the jail?
The only person I had on the list was Mr. Barnett.
Okay, Deputy, can you help us? We don't know who this is and why they're here.
Yes, ma'am. You have a Ms. Turner.
Oh, this is Lakia Turner?
Yes, ma'am.
Oh, okay. Was that already up there or did that just come up there? You put that up there, Ms. Stevenson?
I'm just quick like that, Judge.
You are, because I was going to say, now I know this name was not up here. Okay, I'll put Miss Turner in the breakout room. I don't think I checked for anything on Miss Turner, so I'll see if, well, she's in jail, but I'll see if I have anything. All right. All right, Miss Rubio, I have a Burgess that's supposed to be for Riplet. Are you the attorney of record?
No, I'm not. I'm just standing in for Mr. Burgess. He's in trial right now.
Okay. Mr. Riplet is not present. So
Yes,
I don't know if you have a phone number for him, but he's not present.
I've noticed that. I was trying to reach our administrative assistant to try to find out what's happening. So I'm going to look into that. Thank you.
Okay, and then I'll put you back in the waiting room briefly, but he's not present.
Okay, thank you so much.
All right. Hold on, let me catch up with the chat before I ask questions. Oh, Miss Ritter. Oh, wait, your witness left. They can't connect. I don't know. Okay, can y'all remind me? Because didn't I just do that the other day? Dang it, I don't have my notes. Hold on. Mr. Flanagan, did I give you the Dixon file back when I gave you the group of stuff?
Yes, Your Honor, I have it.
Okay. I didn't mistakenly give you my notes, did I?
I think so.
I don't think so. But did I write in the file?
Yep, you wrote in the file.
Okay. I'll ask you what I said in a minute, but.
Okay.
All right, let me just print this and see. Uh-oh. What? See what I'm saying? Y'all saw Ms. Boyd come breakout room. And I hope she wasn't sounding like that in the breakout room. Because that's a mess. Is that how she was sounding in the breakout room?
Not sure. I'll find out, Judge.
Yeah, because somebody should have tried to fix that. Okay. All right, let me. Try to print this again. All right. All right, good morning, Mr. Martell.
Judge.
Are you ready on Dixon?
I am, Judge.
All right, Mr. Dixon can come up to the podium. All right, this is case number 225843001. The people of the state of Michigan versus Rashad Jamel Dixon. Defendant is charged with one count of attempt police officer assaulting, resisting, obstructing. Today is the date set for review. Mr. Martell, your appearance, please.
Thank you, Judge. Good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Edward Martell, P85051, on behalf of Rashad Dixon, who joins me in the courtroom. Mr. Dixon, please state your full name loudly for the record.
Rashad Jamel Dixon.
Today is the day set for review. I remember that Mr. Dixon showed up on Zoom the other day with a lawyer that was standing in for you, and I even think I remember saying Mr. Dixon had to come in person. What I don't remember necessarily is why, but it could be because he's done nothing. But Mr. Flanagan, what did I write in the file? Did I write anything special in the file?
Quote, 2/6/24, review held, adjourned to 2/13/24.
That's all I wrote.
Yes, Your Honor.
Okay, that's good for Mr. Dixon, because I don't have my notes, and I might have left them on my desk. Okay, but he's done nothing, Mr. Martell. What's going on?
Thank you, Judge. If I may.
You may.
Thank you, Judge. First and foremost, Judge, let me apologize to this honorable court for not being here. Myself and Mr. Nassar are in trial across the street. Certainly, this court is a priority, and I made it a point to get here early, as well as instruct Mr. Dixon to be here early today. Certainly, we have the utmost respect for this honorable court. As for Mr. Dixon and his lack of movement on the requirements of this honorable court, I have had a firm talk with him. He needed this swift hand of Your Honor to get on point. He has forwarded me over some things he has done, including make 2 payments and enroll in the anger management class, which he starts on February 28th. In addition, the Third Circuit warrant is cleared up. He's presently on a GPS tether from the Third Circuit Court regarding that, and has a review date for that. Judge, I would ask to close this matter out because it's somewhat redundant. However, I know he does have an outstanding balance. So I'm going to ask to set this matter for a review and review this progress in possibly 90 days, Judge. I think at that point we'll be able to get a better gauge. But he is on probation with 2 courts, being that of yours as well as across the street, Judge, with Third Circuit.
So I'm glad to hear that the warrant has been lifted from across the street. And maybe that was also one of the reasons that I was not pleased. So I'm glad that that's lifted. He's currently on a GPS tether. I can tell you now, I'm not going to discharge him without improvement. But what I will do, Mr. Martell, do I have, or does probation have the probation order from Third Circuit Court? If I can get the order from Third Circuit Court, so I can compare the two, because I'm not about if he's doing something for me, or if he was ordered to do something for me, but he's also doing it for the circuit court, he doesn't have to do it twice. I'm not about that. But yes, so get me a copy of the circuit court order, or get it to probation. Let me review it and compare it. I do want him to do the class with choices, though. And then it seems like maybe and then he does have the balance. So, is he testing for circuit court? Is he drug testing for circuit court?
He is not, Judge. If you may recall, Mr. Dixon served our country, was discharged honorably from the armed forces, and is presently on disability. He does have a medical marijuana card. Alternative to medical marijuana, I don't believe there's any issues with as far as testing. I know there was some underlying mental health issues that he's dealing with as well. And so certainly he has a lot to overcome, but I stress the importance of making sure that he satisfies these terms and conditions and also timely.
I wish maybe earlier on I would have known that. I try to make sure that I give all veterans an option. Thank you for your service. But I try to make sure I give all veterans an option to go to Veterans Court with Judge Holmes. I'm not going to do that now because I think even with the Veterans Court, she needs 14 months. So let me get a copy of that other order. And then I want him to do the class with Mr. Rice, and then maybe we can make some adjustments based on his circuit court order. I mean, Mr. Dixon, when they start forgiving people loans and stuff and paying off my friends' loans, I was like, I should have joined the military, but I wouldn't have been able to make it. I can't take I can't take stuff. So, I appreciate the people who do serve. That the boot camp is just one big hazing episode. That's how I feel. And so I would be talking back. They would kick me out. I know already, so no sense of going, right? So I do appreciate you, but we want you to be successful on this side of of everything that's going on. Okay. So I'm definitely not here to make you, to cause you to fail at the probation. I definitely don't want to put you in jail. I never would want to do that. But I do need you to just finish this probation. But let me see what he's doing for circuit court, and then I might be able to make some adjustments to this case. So we can come back in 90 days. Well, I think he's already let me see. It said I put him on, for 15 months. So if I do 90 days, that's almost 12 months because I put him on in April of last year. This is February, March, April. Oh, that is 12 months. Let's do more like let's come back at the 12-month mark and see if I can make some adjustments. April what about April the 26th? Is that good for you, Mr. Martell? That's a Friday.
Yes, Judge. The 26th?
Yes.
Perfect. Thank you, Judge.
Okay, let's come back April 26th. Let's make sure I get a copy. I'm gonna write this note. Need copy of circuit court probation. And then if he does I didn't have him doing anger management. I have him just doing the aggressive self-realization program with Mr. Rice. If he goes ahead and does that, I might discharge him. Let's just see where he is and give me a copy of that circuit court order, okay?
Yes, Judge. Thank you.
All right. Anything further?
Absolutely nothing, Judge. Always a pleasure.
Always a pleasure, Mr. Martell. And you have warmed up to me. Okay. You had warmed up to me when you said you knew how important I was over that circuit court. I mean, just tell the judge I said I'm out. You was like, just tell him I had to go to Judge Bryant because
yes, Judge.
Hello.
He is important.
Absolutely.
He is important.
Have a great day, Judge.
All right, you as well. You as well. That's so. I don't understand why Mr. Stokes would come out their breakout room, knowing that we are in a court Zoom, putting his ear and stuff up to the thing and talking and interrupting us. Okay, you all have a great day and stay safe.
You as well, Judge.
All right. And then now Ms. Stevenson want to put him in the waiting room right quick or whoever. After I'm trying to tell him to stop, and then she want to put him in the waiting room. Okay, the jail said they need their camera. Let's see if they took Miss Turner away from the camera. Oh no, there she is. Okay. All right, we're ready on Turner. Let's go with Turner. I did not mean to do that. And then I want to address, was there another witness? Oh, that witness, they not here. Okay, let's do Turner. This is case number 174489801, the People versus Lakia Tiffany Turner. The defendant is charged with 1 count of, malicious destruction of a building. Today is the day set for review. Ms. Stevenson, I'm sorry, I didn't even check. But Ms. Stevenson, your appearance, please.
Janice Stevenson appearing on behalf of Ms. Lakia Turner. Ms. Turner, when you're able to do so, please tell the judge your full name.
Lakia Tiffany Turner.
All right. And I'm sorry, I assumed it was Ms. Stevenson. Today is the date set for review. I don't have anything on Ms. Turner. Mr. Flanagan, by any chance, did you send me the ROA?
No, Your Honor, I'll do that right now.
All right, Ms. Stevenson, what's the situation with Ms. Turner? It's a 2017 case. Do you know when she got on probation?
I do not, Your Honor. I can find that
Do we
out
know
right
how
now.
long she's been in custody now?
She's been in custody at the Wayne County Jail, I believe, at least since December 10th, Your Honor.
What makes you believe
Well,
that?
she's that was her arraignment date on the capias, Your Honor. But I think
On the capias for this review?
Yes, Your Honor. There was another matter which actually caused Ms. Turner to come into custody while this warrant was outstanding. And I believe that is the matter for which she remains in custody, because bond at arraignment on the capias, but for the magistrate was set at personal bond with a GPS tether.
Okay. Ms. Turner, can you get the deputy?
Okay.
Ms. Turner, how long have you been in jail?
Since December.
What's your other charge?
I'm not sure.
Okay. The deputy not coming?
He said in a minute. Give him a minute.
No, don't worry. You don't have to keep. We'll wait a minute.
Okay.
He might just think you ready to go, but we'll confirm, and then I'll
I have another charge.
Ms. Stevenson seems to think that you might have a felony case. I don't know. Oh no, you said she got a personal bond on that case.
She got a personal bond on your case.
Oh, well, then why
is why that's why I'm thinking that there may be a felony.
Deputy?
Good morning, Judge. How are you?
Good morning. I'm wonderful. How are you?
Good. This Deputy Turnbull.
Okay, yes, our Deputy Turnbull. 2 things.
Yes, ma'am.
I would like to confirm when Ms. Turner was booked into the Wayne County Jail, and then I would also like to know if she has any felony case pending, because Ms. Stevenson seemed to think she had a personal bond on my case.
Okay, if you give me a couple of minutes, I can check into that, Your Honor.
Yes, ma'am. Thank you. All right, hold tight, Ms. Turner. Let me figure out what I'm gonna do. Well, once I get that information, I'll know what I'm gonna do. Okay?
Okay, thank you, ma'am.
You're welcome. Mr. Boffman, are you ready? You're not on your camera. Okay. All right, let's do Boyd. And then Ms. Stevenson, is that Edward? Is that Edward on the front row?
Yes, Your Honor, we're all set with Mr. Edwards.
And then what happened to Mr. Ling Leong? Is that him again, still on his telephone? Y'all don't know. Remember, Ms. Stevenson, we put a name. I don't remember the telephone number. So you all never determined if he needed an interpreter?
Can you
Yeah.
chime in on that, please, Mr. Byrd? He
I
was
don't
on the
think,
phone
did
initially.
he ever go, did you ever go in there on the, with the person that was on the telephone?
Never spoke with him, Your Honor.
Yeah, he sounded like he had a thick accent, and so I don't know if he needs an interpreter, but I'll get to him in a moment. All right, I'm ready on Boyd. This is case number 194595401, the People versus Mary Lynn Boyd. Defendant is charged with operating with a high BAC and operating while intoxicated with an occupant under the age of 16. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And yes, Your Honor, Brandon Byrd on behalf of Mary Boyd. Ms. Boyd, can you please unmute yourself and state your full name for the record?
Mary Boyd.
Mr. Byrd, she was sounding like that in the breakout room with all that static and stuff.
She was, Your Honor.
Oh, you should have had her log off and do something else. But okay, today is the day set for pretrial conference. Are we sure it's supposed to be for pretrial conference? It's a 2019 case. Mr. Flanagan.
Yes, Your Honor. She was first arraigned on a bench warrant.
But so go back. If she was arraigned on a bench warrant, go back to why did the bench warrant issue? What happened before that bench warrant?
Yeah, this is weird. There's no arraignment in there. It says the filing date was November 17, 2019, and the warrant was canceled December 11, 2023, and arraignment on the bench warrant.
For me today?
Oh no, she was arraigned on the bench warrant December 11th by.
I mean, I'm sorry, yes. And then they set it for pretrial today?
Yes, yep.
Okay. All right then, Mr. Byrd. I'm sorry. Mr. Byrd.
Yes, Your Honor. Actually, we'd like to set this matter for a final pretrial and respectfully request discovery. But if I can address bond, I would appreciate it.
Court is going to continue a not guilty plea on behalf of Ms. Boyd. Ms. Ritter, earlier today, I gave a final pretrial conference for 2 months instead of 3, and then I set discovery due by the March. Is that enough time for the people on this case?
It is, Your Honor.
All right, then the court will set a final pretrial conference for April the 22nd at 9 o'clock with discovery due March 22nd. And then bond, you can address bond. You can address bond because I am going to probably be adding a condition. Oh, wow. Okay. I will be probably adding a condition, but Mr. Byrd, you can address bond.
We were going to ask for removal of the alcohol tether. We understand. We were expecting that testing. You might have added a contingent at testing, but she's actually on the alcohol tether. She's been on that alcohol tether since December. Hasn't had any violations. She hasn't had any criminal cases, including any criminal cases, since that 2019 incident, Your Honor. She has had some traffic violations in which she's cleaning up, but she hasn't had any criminal cases. She hasn't had any violations of that tether condition. And actually, the tether is just embarrassing for her. I understand it's not stopping her from doing her job, but it's embarrassing for her. People don't know why she's on the tether, and doesn't like that perception being brought to her. And she's looking to put this matter behind her, but we're just asking for removal of that alcohol tether. It has been 5 years since this matter's happened. And in those 5 years, no criminal convictions, not even charges brought against her, Your Honor.
All right. Of course, Ms. Ritter, it would be my intention to remove the alcohol tether. Any objection from the people?
So, Your Honor, I do understand that this case did happen in 2019. However, due to the nature of the charge, it looks like the occupant that was less than 16 years old was about 5 at the time of this incident. And according to the police report, Ms. Boyd's alleged blood alcohol content was 0.17, which is over twice the legal limit in the state of Michigan. So I am going to ask the court actually to keep the alcohol tether. If the court is not inclined to do so, Your Honor, I'm asking the court to have Ms. Boyd random urinalysis at least 4 times a month.
The court is going to remove the alcohol tether. And while she has not had any other incidents that we are aware of since the date of this alleged offense, I am going to order, I'm not going to order 4 times a month, but I am going to order 3 times a month. Due to the age of the case, I'll order the 3 times instead of, if it was a more recent case, I would order 4 times a month, but I'm going to order 3 times a month urinalysis. Now, there is no room to miss. So I understand oh, okay, that you know, a tether may be embarrassing and all of that, and I understand that. So please know though, she has to test. And when I say test, if they call you on a Tuesday, Ms. Boyd, you cannot go on Wednesday. Don't waste your money. Random urinalysis means exactly that. It's random. We don't know when we're going. We don't know what day we're going until they call us. So they give you, you know, I think the whole day to go or whatever. So you're going to have to go on that day. If you go the next day, it doesn't count. So I'll remove the alcohol tether and she can submit to urinalysis. Probation will contact her. So make sure we have current contact information, okay?
No problem, Your Honor.
All right. Anything further for the record?
No, thank you, Your Honor.
Nothing further, Your Honor. Thank you.
All right, Ms. Boyd, you're all set. Have a great day. Stay safe.
Thank you so much. I really appreciate that, Judge. You too. So I go back to my attorney.
Say that again.
Do I go back in the break room with my attorney?
No, he should have your contact information. Probation is going to contact you to set up the testing, and we'll have the tether removal order sent over to the tether unit.
Okay. Do you know how long will it be for? I'm sorry. I heard you say something about the 22nd in April of March and April 22nd.
Your next court date is April 22nd. Okay. Give us until this afternoon, and you can contact the court about the tether, getting the tether removed. So give us until this afternoon. You can call my clerk to see if I've signed the order. 965-2295.
965-2295.
2295.
Thank you so much.
All right, you're welcome. Have a great day. Stay safe.
You too. Bye-bye.
Deputy. So
yes,
for the felony thing, my clerk, somebody sent me the answer that Judge Jefferson ordered competency. And she has a competency hearing May 1st.
So in regards to your case, we show in our system a personal bound with tether. However, the tether unit is unable to verify her address. So they got a tether ineligibility form in there. And I'm felony holds currently at this time.
Say that again. You said no felony holds?
Correct.
Oh, well, Ms. Stevenson, I don't know what that, Ms. Stevenson seemed, but maybe her bond is, I don't know. According to Ms. Stevenson, she should have a competency hearing May 1st. However, thank you for that information, Deputy. Oh, sorry, Deputy. So has she been there since December?
She has been here since January 1st.
Okay. All right. Okay, thank you. So She was charged with malicious destruction of a building on my case. She was placed on probation. And let me see, Mr. Flanagan, I think, sent me the ROA, I think. But where's my email? Okay. So I believe I'm going to, my email not working. It's swirling, Mr. Flanagan. Okay. So tell me, it's not working. Tell me, how long was she placed on probation for?
It looks like she wasn't placed.
What do you mean?
The sentencing date was October 30th, 2018.
And she case dismissed?
Looking for your honor. Oh, it was a delayed sentence.
Okay, for how long?
9 months.
Okay. And what did she have to do?
Looking for an order.
Don't worry. The court is going to amend her sentence, and I'm going to give her hold on. So deputy says she's been there since January 1st. And so on February 1st, that would have been 32 days. And then today is February the 13th. So the court is going to give her 45 days in the Wayne County Jail. Credit for 45 days served. Close the matter out without improvement. And I don't know, deputy, maybe you all should check. So that ends this case. But Ms. Stevenson seems to think Ms. Turner was referred for competency by Judge Jefferson on a resisting and obstructing charge with an offense date of December the 8th.
I can look into it, Your Honor.
Yeah, so I'm sure before they release her, they would know if maybe she's on a personal bond, Ms. Stevenson, I don't know. But nonetheless, this case is closed.
Right.
Okay.
Does Ms. Stevenson have a case number?
Oh, Ms. Stevenson, do you have a case number?
I did, and I will again.
And then while we're doing that, Mr. Edward can come to the podium.
I have, when the deputy's ready, 2306 038201.
Okay. And Judge, would you like us to contact your courtroom if this matter is over, or you want me to come back on camera?
No, I'm all set. I just wanted to make sure whatever Judge Jefferson's, because you said you weren't showing any other holds. So no. I just wanted to make sure, that you all, whatever that case is, I don't know what her bond is. But as for my case, she's all set, and you don't have to come back and let us know anything. I mean, Ms. Stevenson might be interested in the other case, but I'm not. Okay. Have a great day, deputy. Stay safe. All right, Miss Turner, you're all set with me. You have a great day. Stay safe. They might be letting you go today, okay?
Okay, thank you, ma'am.
All right, you're welcome. All right, uh-oh. What that is, that bill. I'm ready on Edward. This is case number. Mr. Boffman, whenever you turn on your camera, that'll let me know you're ready. Okay. This is case number 136306401. The people of the state of Michigan versus Terrence Bernard Edward. Defendant is charged with driving while license suspended, revoked, denied, operating with the high BAC. Today is a date set, final pretrial conference. before I take appearances. Mr. Flanagan, maybe you could call Mr. Boffman. Was he aware that his client was here? Well, his client gone now though. Oh, his client is gone now. Okay. Oh, then I forgot about this person too. All right, appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Terrence Edward. Mr. Edward, sir, please tell the judge your full name.
Terrence Bernard Edward.
All right, today is the date set for final pretrial conference. How are we proceeding? I'm going to share my screen for Mr. Riplet, but I'm listening because he's not connecting. But you all go ahead. How are we proceeding?
Your Honor, it is my understanding that by yesterday, well, first of all, we thank the court very much for allowing Mr. Edwards' matter to be adjourned from yesterday to today. The court did order give Mr. Edward the opportunity to come to court in person today rather than having a warrant issued for his arrest for failure to appear yesterday. And we are grateful for that, as Mr. Edward does stand before you in person. It is my understanding that by yesterday, the people were to have determined whether or not their necessary witness was available in this 2013 case. If the people have not determined the availability of their necessary witness, we would move that the matter be dismissed.
Ms. Ritter?
Your Honor, the court did set a final pretrial for yesterday and wanted the people to confirm that the officer witnesses were still available. At this time, the people cannot confirm that those officer witnesses are still available and employed with DPD, which they are necessary witnesses in this matter. So at this time, Your Honor, the people will not be able to proceed due to the age of the case.
All right, today is the day set for final pretrial conference. The people have been unable to locate their necessary witnesses through the DPD, and they are unable to proceed at this time. The court is going to grant defense counsel's motion and dismiss the matter without prejudice for failure or as the people cannot proceed. Normally, Mr. Edward, I would tell you to have a seat and I would give you a copy of the order right now. However, my computer is malfunctioning a little bit and I need to log off and log back on to reboot my email. So right now I can't sign the order. So we will mail you a copy of the order of dismissal for your records. Unless, Mr. Flanagan, do you have a signature stamp for me?
Yes.
All right, go ahead and do the order. Stamp it with signature stamp, seal it, but I will also still sign the order. So still put it in with the orders for me to sign.
Okay.
So to give him a copy while he's here. All right, so sir, just have a seat and wait for a copy of the order.
Thank you, Your Honor.
You're welcome. All right, I'm ready on Riplet. This is case number. And then Mr. Flanagan, I think I cut you off because Mr. Boffman's client wasn't here, but now his client is back. Maybe you could call Mr. Boffman.
Okay.
All right. This is case number 2259-25401, the people of the state of Michigan versus Vance Martinez Riplet. The defendant is charged with. No, he's not charged with this. Okay, my docket says carrying concealed weapon, but that's not the truth because this is the misdemeanor docket. And then he's charged with assault or assault and battery. Today is the day set for final pretrial conference. Ms. Ritter, your appearance and correct charge, please.
Yes, Your Honor. For the record, Christina Ritter on behalf of the people. And Judge, that is correct. Count 1 was dismissed and the remaining charges is on assault or assault and battery.
All right. So I know I asked Mr. Flanagan to do something else, but we're going to make sure that count 1 is removed from the system. We got to make sure that's removed. All right. And then Ms. Rubio, your appearance, please.
Good morning. Thank you, Your Honor. Mary Rubio for Mr. Riplet, standing in for Mr. Burgess, hopefully with Mr. Riplet's consent.
Your P number.
Oh, I'm sorry, 64626.
And Mr. Ripley, you consent to Ms. Rubio standing in for your lawyer today, who I believe is in another hearing. Unmute yourself, sir.
Yes, ma'am. Sorry about that.
Okay, and then state your name for me.
Vance Riplet.
And is your middle name Martinez?
Yes, ma'am.
Today is the day set for final pretrial conference. Ms. Rubio, how are we proceeding?
We're keeping this on track for trial. It's my understanding there already is a trial date set for April 22nd.
All right, the court continues a not guilty plea.
If I may, Judge.
Maybe, hold on. Oh, yes, on behalf of Mr. Riplet, and the matter is currently on the court's docket for a jury trial Monday, April 22nd. Ms. Ritter?
So, Your Honor, that is correct. There is a jury trial scheduled for April 22nd, 2024 at 10:30. However, the court did set this final pretrial conference requiring the complainant witness to appear. And at this time, Your Honor, I don't see the complainant witness, Ms. Shannon Roberts, in the waiting room, and the people don't have an explanation as to why she has not appeared today, as she was required to appear at today's final pretrial conference. So at this time, Your Honor, the people will not be able to proceed to the jury trial set on April 22nd.
All right, then, Ms. Rubio, the people said they can't proceed.
Then at this time, we would make a motion to dismiss.
Court is going to grant defense counsel's motion and dismiss the matter without prejudice. The matter, it was on the court's docket for jury trial. The people have indicated they have been unable at this time to locate their complaining witness and cannot proceed to that jury trial. Ms. Rubio, if you could submit an order of dismissal to my clerk, who will put his email address in the chat for you. I will sign that and get it back to you or to Mr. Burgess, Mr. or Miss Burgess. I don't know.
Mr. Burgess, perfect. Thank you. I will do that.
Okay, then we're all set. And then Mr. Ripley, your lawyer will get you a copy for your records, okay?
Okay, thank you, Your Honor.
You're welcome. Have a great day. Stay safe.
You too.
Thank you. You too.
All right, thank you. Great job, Ms. Stevenson. The 2 afternoons are here. And let me see if I have any information, because I don't know. Did I send you something on them? Did I send you anything on those 2, Ms. Stevenson?
You did send something on, was it Tucker, Mr. Bird?
Tucker, but not Luster?
Correct.
Let me look. Oh, I can't look. Oh, man. I can't. Okay, I can't look. Let me dismiss this witness. Who's the probation officer on Luster? Maybe I'll just log off and log back on so I could get my email. Mr. Morris just keep on. Okay, Miss Ritter, I don't know what happened to Mr. Morris just now. Good. All right, Mr. Boffman. Let me bring it. Tucker. Okay, I'm sure she probably sent me something. Can you call Miss Tucker and ask her to send whatever update she sent me? Can she just send it to you so you can forward it to Miss Stevenson? Because I can't access my email right now without logging on. Okay. All right. Let's see. Oh, then I don't have any ROAs or anything. All right. Good morning, Mr. Boffman. I hope you're feeling okay.
Please the court, Your Honor. I am feeling well enough considering I was feeling lucky. I had never contracted COVID until this weekend. So please be careful and
I stay away from y'all humans.
Get it.
I've still been blessed enough not to get it. Okay, your client, let me share my screen and see if he can connect. He's been here. Maybe he might have walked away from his device, but let me, whoops. Whoops. Let's see. I'm going to share my screen and see if we can get him to connect. In the meantime, Ms. Stevenson, are we, or Mr. Byrd, are we ready on Lowther?
Ready on Lowther, Your Honor.
All right. All right, I'm ready on Lowther, and you all probably can't see me. You probably can see the share screen, but I'm trying to get Mr. Evans to connect. So I am going to keep the share screen up for a minute. But with respect to Lowther, this is case number 234569901. People of the state of Michigan versus Joseph Lee Lowther. Defendant is charged with reckless driving. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Yes, Your Honor. Brandon Byrd on behalf of Joseph Lowther. Mr. Lowther, please unmute yourself and state your full name for the record.
Joseph Lee Lowther.
All right. Today is the day set for pretrial conference. Mr. Boffman, if you have Mr. Evans' phone number, maybe you can call him and see if he can come to his device. All right, today is the date set for pretrial conference. With respect to Mr. Lowther, how are we proceeding?
We would like to set this matter for a final pretrial and respectfully request discovery, Your Honor.
All right, the court is going to continue a not guilty plea on behalf of Mr. Lowther. Set the matter for final pretrial conference, April the 22nd. At 9:00 a.m. Discovery should be submitted by March the 22nd. Bond will continue. Anything further?
No, thank you, Your Honor.
Nothing further, Your Honor. Thank you.
All right, then we are all set. Have a great day and stay safe. Mr. Lowther, your next court date is April 22nd at 9:00.
Okay, is it the same Zoom number?
Yes, sir.
Okay, thank you, ma'am.
You're welcome. All right, I'm ready on Stokes. I'm going to bring in Tucker. And then I don't know who, Miss Stevenson, Miss Ritter, was your witness's first name Robert?
Yes, Judge, that's him.
Okay. Which case is he on?
Lofton, and I don't know if Mr. Lofton is here or not.
No, that's why I was gonna let him go, but I did wanna acknowledge his presence. I'll go ahead and bring him in. This is Stokes case number 204559601, the people versus Shantez Stokes. The defendant is charged with assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Yes, Your Honor. Brandon Byrd on behalf of Shantez Stokes. Mr. Stokes, please state your full name for the record.
Shantez Malik Stokes.
Today is the day set for pretrial conference. How are we proceeding?
Respectfully requesting dismissal if there's no complaining witness, Your Honor.
Ms. Ritter.
Your Honor, I don't see the complaining witness, then Janice Cochran. However, it's scheduled as the first time pretrial conference. I respectfully ask the court to adjourn the pretrial conference and give the complaining witness one more opportunity to appear.
All right, the court is going to deny defense. Okay, sir, please don't do that. Please do not do that. Do not. Today is a day set for pretrial conference. The court is going to deny defense counsel's motion for dismissal, grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I am going to adjourn the pretrial conference to April the 1st at 8:36. Oh, no, I'm not. Oh, why did I do that? Today is February what?
13.
Oh, that was, Ms. Ritter, was that enough time I did on Sherelle? I adjourned it to April 1st.
That's fine, Judge.
April 1st is fine?
Yes.
All right, the court is going to adjourn this matter to April 1st, 2024 at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further with respect to Mr. Stokes?
Not on behalf of the people, Your Honor.
Nothing further, Your Honor. Thank you.
I mean, Mr. Stokes, what's going on right here? What are you saying? What's going on? Who says to the judge it is what it is? And
no, I didn't say that. No, I said I don't even know who that person is.
Oh, okay.
Yeah, I didn't say that. No, I wouldn't. I wouldn't dare say nothing like that.
I was thinking.
No, I would. No.
Not
no,
my
I
client,
don't even
Your
know
Honor.
that person.
Not your client, Mr. Bird.
Not my client, Your Honor.
No, not me. I got my manners. I have good
Your
manners.
manners are impeccable, Mr. Stokes.
Yes, ma'am. Yes, ma'am. No, for real.
I said, why is he saying it is?
No, I ain't not. No, I ain't disrespectful like that.
Thank you, Mr. Stokes.
Oh, yeah, no problem.
We're all set until April 1st, and we'll see if the complaining witness appears, okay?
Okay. All right. Thank you.
Great day. Stay safe.
You too.
All right. Okay, with respect to, tell me again, Ms. Ritter, what's the, Lofton. All right, with respect to Lofton, Ms. Stevenson, that's at 9:10. Are you?
I don't have any information for the court. I'm sorry about that too.
What day is that scheduled for?
That is, I have it. Sorry, look it up again.
Okay. Or Mr. Flanagan, if you have it, what day is Lofton scheduled for? Because I'm into March and I don't see it.
April 22nd.
Oh, that's the same day. Okay. Oh, it sure is. Okay. All right, so with respect to case number 234444001, Jason Lofton. All right, well, appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. I have the complaining witness present via Zoom this morning. Mr. Morris, there's a prompt to unmute yourself. Unmute yourself and just state your name for the court.
Robert Morris.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Jason Lofton. And Your Honor, I have attempted to contact Mr. Lofton and I have not been able to reach him, Your Honor. Most recently as yesterday, I haven't been able to reach him.
Today is the day set for final pretrial conference. Mr. Lofton has a jury trial scheduled for April the 22nd. Mr. Flanagan, has Mr. Lofton capious before?
No, Your Honor.
All right, so Mr. Lofton has not capious before. And this jury trial is now the second in priority. Mr. Flanagan, when is the final pretrial conference for Abu Tam? I feel like it just happened.
Final pretrial, Your Honor, is February 23rd, 9:10 a.m.
All right, so because Mr. Lofton has never capious before, then the court has to adjourn his final pretrial. I won't remove him from the jury trial docket since I do have one other case also scheduled for jury trial, but I'm going to set this matter for another final pretrial conference, February the strike that, I'm sorry. March the 20th. Nope, I apologize. Don't write that down. Don't write that down. Mr. Flanagan, what's my docket like on March 8th?
$33.
What's my docket like on March 13th?
$22.
Court is going to adjourn this final pretrial conference to March 13th at 9:14. And Mr. Lofton, of course, if he fails to appear at that time, what did I just say? March 13th. Court is going to revoke his bond and issue a capious and a warrant for his arrest. So, Mr. Morris, if you want to know firsthand what occurs, you can show up on March 13th. Otherwise, the prosecutor will contact you by telephone, okay? Anything further?
There is one thing on behalf of the people. So I had an opportunity to speak with Mr. Morris, and he's brought to the people's attention that he did have a scheduled trip on the day of the jury trial that's scheduled for April 22nd, 2024. And he did send over a copy of his itinerary to the Victim Advocate Services. So I'm asking the court, at this time, can we have another jury day, or should I address that at our adjourned final pretrial conference?
Hold on one second.
Mr. Morris, stay still for me, please.
I mean, here's the problem. Now, this jury trial date has been set for a long time. And in order for me to adjourn the jury trial, be clear that we are now into September and October. So if your witness is now not available for the April jury trial date, then I'll adjourn. At this point, I need to see if the defendant is going to show up. But then in March, if the defendant shows up, I will adjourn the jury trial, and it's going to be way later. Like and quite frankly, that's unfair to the defendant. Why would Mr. Morris schedule a trip and we knew this jury trial date was here?
Well, from my understanding, Judge, this trip was already pre-planned. So
when did he show up the first time? Did he tell us he had a pre-planned trip the first time?
So the first appearance was August 30th for the pre-trial. And then the final pre-trial was November 1st. And then the people received the information about the trip at the beginning of 2024.
So when the court all right. I mean, I don't know what to tell you. We'll see. We'll see if the defendant shows up. If he does, then we could address it at that time.
Okay, Your Honor, thank you. Nothing further from the people.
All right.
I'm sorry, Your Honor, nothing on behalf of Mr. Lofton.
All right, then we're all set, sir. Have a great day. Stay safe. All right, Mr. Evans. Okay.
Good morning, Your Honor. How are you?
I'm fine, Mr. Evans. This is case number 234432601, the people versus Frank Jeron Evans. Defendant is charged with guns, possession while operating under the influence. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record,
Good morning, Your Honor. Oh, I'm sorry. Go ahead.
For the record, Your Honor, Christina Ritter on behalf of the people.
May it please the court, Harry Boffman, P55052, on behalf of the defendant. Mr. Evans, state your full name.
Frank Jeron Evans.
Thank you. Your Honor, we're asking respectfully if you would set aside the warrant, set this matter for a pretrial. The defendant has another case in the 36th District Court before Judge Roberta Archer that comes from the same transaction or events. I've spoken to both Corporation Counsel as well as the Wayne County Prosecutor's Office, and we've agreed to something, and we would ask if we could follow that date of February 20, 2024 at 9:10 a.m. The defendant did appear at the last action date, which was February 6, 2024, but was unable to complete his appearance due to some personal conflict, and where he was actually asked to leave the courthouse by, I think it must have been court personnel, not the bailiff.
Excuse me, I have to correct that. I wasn't asked to leave, Judge.
Okay. I stand corrected. Say less, though, Mr. Evans, please.
Yes,
okay?
sir.
Thank you. So we're just asking the defendant, this is important to him. I'm here as counsel for him for that purpose. He and I have communicated. He is not recalcitrant in any way with respect to the instant case and a resolution. I anticipate that will happen next Tuesday with the permission of the court. He's on alcohol tether, Your Honor, as well, without incident.
I don't think I have space next Tuesday, but let's see.
It's okay if we can't do it. I'm going to rely on whatever's convenient for the court.
But Mr. Flanagan, do I have a bench trial that day, don't I?
Yes, Your Honor.
Jemerson at 10:30.
That's my case. Oh, that's not my. No, it's not. I'm sorry. I have a defendant named Jimerson, but not in here.
Let's do this, Mr. Boffman. I don't know what resolution you all are attempting to do, but what I'll do is I won't put him on my docket for the 20th. I will put him on my docket for, how many do I have on the 28th, Mr. Flanagan? Wait, I'm still working out of 2 books, Mr. Flanagan.
23, Your Honor.
All right, Mr. Boffman, the 28th is better for me.
Understood, Your Honor. I'll make myself available. Thank you.
Okay, and if, so I'm gonna set it for final pretrial conference, February 28th at 9 o'clock. But if there's some global resolution that includes, you know, dismissal of my case, or just let me know. I mean, Ms. Ritter will be available that on the 20th, whatever you all are trying to do.
I hear you loud and clear, Your Honor. We'll try to make it happen.
Okay. All right, then we're all set.
Thank you. Have a great day, everyone.
Okay.
Bye.
Thank you, Your Honor. Enjoy the rest of your day.
All right, you too. What? All right. I'll let these two last one is it? Oh. Did we get the update on Luster?
Yes, Your Honor. I received it and I forwarded it to Ms. Stevenson.
Okay, thank you.
Mm-hmm.
Thank you.
You're welcome.
Ms. Stevenson, can you go in and talk to this phone because I can't. I don't want them to hang up, or somebody go in and talk to the phone. So we can
Talk to him, Your Honor.
I believe this is Ling Leong, and they may need an interpreter. We might have to adjourn them because they're not on video anyway. So I'll send the phone there now. So if you could go in, because they left before. I guess y'all took too long. So all right. And I'm gonna send Mr. Tucker to a breakout room as well. I can't see his review, but after I do these 2 cases, maybe I can log off and log back on.
Okay.
And then, yeah, and then I'm gonna have to kind of hurry up because apparently they just moved that procedure up. Okay. All right. Let's do Terry and then Thacker.
Terry's a plea judge.
Okay, well, let's do Thacker and then Terry.
Okay, thank you, Your Honor.
That sounds like what you want me to do.
Oh no, I just wanted you to know. But yes, that's what I wanted you to do.
I know it is. Well, if Mr. Thacker starts his video, otherwise I am going to do Terry first. Mr. Thacker, are you there? Okay, Mr. Thacker isn't there, so I'm going to go ahead and do Terry, and then we'll bring Thacker in.
Hello?
Oh,
Hello?
yeah, okay, you
Can
took
you
a
hear me?
long time. I can hear you.
Yeah, I'm sorry.
We was just getting ready to put Mr. Terry. Mr. Terry wasn't sorry. He was like, yes, stay off video. All right. I'll do Thacker and then Terry. This is case number 2344-40601. The People versus Brad Felton Thacker. Defendant is charged with 1 count of assault aggravated, 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Brad Thacker. Mr. Thacker, sir, please tell the judge your full name.
Brad Felton Thacker.
Today is the date set for final pretrial conference. How are we proceeding?
On behalf of Mr. Thacker, Your Honor, we move for dismissal for the complainant's failure to appear.
Ms. Ritter?
I don't see the complainant witness, Mr. Derek Mathis, in the waiting room. However, it's scheduled as a first-time pretrial conference. I respectfully ask the court to adjourn the pretrial conference to give the complainant witness 1 more opportunity to appear.
Today is the day set for pretrial conference. I am going to deny defense counsel's motion for dismissal, grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. Mr. Flanagan, am I still good? Miss Ritter, you know when I asked you if April 1st was enough time, you know I was thinking March 1st. I was thinking I was giving you just a little bit of time. But Ms. Flanagan, am I still good on April 1st or have I overloaded myself?
$22, Your Honor.
And the magistrates are there, right?
Yes.
Okay. Court is going to set the matter for April 1st. At 8:36, the complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed, unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Bond will continue with no contact with complaining witness. Anything further?
No, thank you, Your Honor.
No, thank you very much, Your Honor. I'm sorry, the date once more. I'm sorry.
April 1st.
Okay, nothing further on behalf of Mr. Thacker. Thank you, Your Honor.
Mr. Thacker, you're all set. Have a great day. Stay safe.
All right, you too. Thank you.
I need the individual on this telephone to stop leaving so that the lawyers can talk with you. I'm gonna leave him here until Mr. Bird is ready again. I'm ready on Terry. This is case number 234570401. People versus Clayton Jamal Terry. Defendant is charged with operating while under the influence, while carrying a concealed weapon, and operating while intoxicated. Today is the day set for pretrial conference appearances, please. We couldn't hear you.
I'm sorry, for the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Clayton Terry. Mr. Terry, sir, please say your full name.
Clayton Jamal Terry.
Today is the day set for a pretrial conference. How are we proceeding?
Your Honor, Mr. Terry and I have had the opportunity to discuss this matter. And we've also had the opportunity to review together. He's had the opportunity to review with me in advice of rights form. It's my understanding that at this time, Mr. Terry wishes to avail himself of an offer from the people. He'd like to offer the court a plea of guilty as charged to count 2, Your Honor, operating while intoxicated. And it's our understanding the people's offer does include a motion to dismiss count 1 and refile that as a civil infraction, Your Honor.
Ms. Ritter?
That is correct, Judge. That is the people's offer at this time.
We can't hear you.
That's correct, Your Honor. That is the people's offer at this time.
So with respect to the people's offer, though, has it already been dismissed has the civil infraction already been reissued?
Not yet, Judge. I just learned of this today.
Okay, so then the court is going to, at this time, continue a not guilty plea on behalf of Ms. Terry. I need to adjourn the case to give people an opportunity to have the count reissued as a civil infraction. Otherwise, it's going to be still there.
Thank you, Your Honor.
All right, so what about, let's give them at least 30 days, which puts us, well, maybe 2 weeks? Let's see. Today is 13, 1, 2. That puts us like at February 27th. Is that usually enough time, or do we need more time than 2 weeks?
2 weeks should be fine for the people, Your Honor.
All right, let's adjourn to February 28th. Mr. Flanagan, is that a good day for me? I'm sorry.
Yep, 24 that day.
All right. Then we're going to adjourn to February the 28th. And then that way they'll have the civil infraction issue. And then we can do the plea that day.
Great.
Also, wait a minute. Oh, okay, no, I gotta do it. Yeah, we'll do the plea that day. All right, anything further?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Terry. Thank you, Your Honor. Mr. Terry, I'll give you a call in a couple hours.
Okay, thank you.
All right, you're welcome. Have a great day. Stay safe.
You too.
Okay, I'm going to log off. You all could try to talk to that phone again that keeps on coming and leaving. And then I'll be back. I just need to reboot my computer for a minute.
Okay.
All right. Let me make Mr. Flanagan the host, because Miss Ritter be going. Yeah, okay.
And when do I get to say I can't hear you, Miss Ritter? I'll say that now. Oh, me too, Mr. Bird.
That's good to know. Oh, I did really? Okay. All right. So then, yeah.
Okay.
Good morning on the telephone.
Yeah.
Hi, ma'am. What is your name, please?
Jenny Lane Long.
Okay. Ms. Lynn, we're
Yes.
trying to send you to a breakout room. So you have to follow your phone's instructions so that we can speak with you, okay?
But I tell you, I English is very little, not too well.
Okay, can you just hold on a minute? I'm gonna try to call you and I need you to
Okay.
answer when I call you on the telephone. I need you to answer, okay?
Okay.
Thank you, ma'am.
Thank you.
All right, I think I'm back. I'm ready. I can do email. So let's see. We're ready on. Oh, I no longer see Luster on the front row. So we're ready on.
Can I ask a quick question, Judge?
Yes.
So that phone, I have that person on the telephone. She needs a Cantonese interpreter. Could we just get a date?
Yeah,
for
they
her
need to come in
back?
person.
Yes.
Okay.
Just 1 minute, Miss Lynn.
I mean, you could get a date from Mr. Flanagan. I don't know. I mean, I don't know how long it'll take for them to get a Cantonese interpreter. So he needs to, you might have to call them back.
Okay. Thank you, Your Honor.
Okay. All right, I'm ready on Tucker.
Ready on Tucker, Your Honor.
Wait, did I? All right, this is case number 214541301, the people of the state of Michigan versus Charles McKinley Tucker. The defendant is charged with 1 count of gambling, disassociated person. Today is the day set for review. Mr. Byrd, your appearance, please.
Yes, Your Honor. Brandon Byrd on behalf of Charles Tucker. Mr. Tucker, please unmute yourself and state your full name for the record.
Charles McKinley Tucker III.
Okay. Today is the day set for review, but I'm a little confused. I'm a little confused by this, by the report. So, the report indicates that Mr. Tucker has completed, that he has paid his fines, costs in full, that he paid his traffic tickets, he provided proof of Gamblers Anonymous, and has had no contact. But then it says remaining conditions, which to me means remaining, what he has remaining to do, but it says has provided proof of Gamblers counseling. So that's confusing to me. Did he provide proof of Gamblers counseling already?
That's what he indicated to me, Your Honor.
Okay, Mr. Flanagan.
Yes, Your Honor.
Can you call Ms. McCall and ask her, has he completed all the terms and conditions? Because I'm confused by I'm confused by that last statement. So if I'm confused. If he provided it, it should be in completed condition. So just ask her if she has that.
I was a little confused too because it's incompleted and not completed.
Well, no, Gamblers Anonymous is incompleted, but the Gamblers Counseling is in not completed. So they are 2 different things. So, but I need to know, did she get it? I mean, it seems like she got it, so I don't know. Let's just see what she says.
Your Honor, I'm on the phone with Ms. McCall. She indicated he has not completed his Gamblers counseling.
So why she put?
He's just attending.
Oh, that he is attending Gamblers counseling. Oh,
yes,
okay. I see. Has provided proof of attending but he's not complete. How many did I say he had to do?
You said there wasn't no, was not a certain amount on there, Your Honor.
Okay, not a certain amount. How many has he done?
Looking it up, Your Honor.
Okay.
Seven, Your Honor.
7 gamblers counseling?
Yes.
Okay, thank you.
You're welcome.
Um, all right, Mr. Byrd, I'm satisfied.
Thank you, Your Honor.
All right. Court is going to discharge Mr. Tucker from probation. Anything further?
Nothing further, Your Honor. Thank you.
All right, Mr. Tucker, you're all set. We will mail you a copy of the discharge for your records, okay?
Thank you, Your Honor.
You're welcome. Have a great day. Stay safe.
You too.
Thank you. All right. I think that's Mr. Luster sitting back on the why my thing didn't print. Okay, give me a second. All right, I'm ready on Luster. He can come up to the podium, please. Case number 235654301, the People versus Maurice LaShawn Luster. Defendant is charged with 1 count of controlled substance, illegal use. Today is the day set for review. Ms. Stevenson, your appearance, please.
Janice Stevenson appearing on behalf of Mr. Luster. Mr. Luster, sir, please tell the judge your full name.
Maurice LaShawn Luster.
All right, today is the day set for review. And Mr. Luster was placed on 6-month probation in August 2023. So this should be his 6 months. He is randomly testing. He's doing community service. Well, he completed community service, but he, according to this, has a balance and 2 warrants. Ms. Stevenson?
And Mr. Luster is asking the court to give him at least until the end of May to pay the $685, Your Honor. He's already begun the process of clearing up those 2 warrants in those other jurisdictions, but needs to get money together in order to do that, Your Honor.
And he doesn't want to do any community service for the remaining balance?
Oh, I would have Mr. Luster tell the court that on the record if he wants to do some more community service or just pay the $685.
I'll pay the fine, Judge.
All right, let's continue Mr. Luster then to, well, I would have to extend his probation. So he was placed on 6 months, so I'll extend him. How long did you say then, Ms. Stevenson?
The end of May is what Mr. Luster has asked for, Your Honor.
All right, let's extend them then to May. Let's actually go to Tuesday, June 4th, please.
Okay.
10 o'clock. And really, oh, well, we got to check the warrants too. Okay, 10 o'clock, June 4th, I'll extend his probation. All right, anything further?
Nothing further on behalf of Mr. Luster. Thank you, Your Honor.
All right, Mr. Luster, you're all set then, sir. Have a great day. Stay safe.
Yes, have a good day too, Judge. Thank you.
Thank you.
And also, thank you too, Ms. Stevenson.
You're welcome, Mr. Luster. You stay well.
Yes.
All right, and that is, whoops. Oh, I was getting ready to kick y'all completely out right there. All right, then we are